to assess the legal as well as political impact of all of this. We're joined by Professor Magnus Killander, human rights law expert and head of research at the Center for Human Rights at the University of Pretoria. Mr. Thembisa Fakude is a political analyst and head of Africa-Asia Dialogues. We're also joined by Daniel Levy. He's a political scientist and head of the U.S. Middle East Project. Gentlemen, thank you very much for your patience with us and for your time this afternoon. Perhaps as we kick off the conversation, a reflection, because at some moments as South Africa was presenting its case, you could hear a pin drop. And so, Professor Magnus Killander, how do you capture this moment? Briefly, please.
No, I think it was an important moment. I guess many of the arguments didn't come as a surprise. I mean, we have the submission that was done by South Africa, but I think they presented a very thorough case, having adjusted to the time. I mean, first given 2 hours, now it became 3 in the last day or so. I think it was a very clear argument, and we will have to see tomorrow then how Israel responds to this.
Absolutely. We'll get into the argument in a few moments. Mr. Thembisa Fakude, you take a breath and you describe this moment as?
Well, it was bad news for Israel in terms of its public relations and in terms of its image internationally. But also, for some of us who have given up on multilateral platforms, there is that glimpse of hope that at least we still have these platforms that can bring some sort of hope and demonstrate why they were initially established. So today we saw the ICJ being resuscitated, and hopefully tomorrow is going to be even much more interesting. But I think overall today, the ability for the lawyers to paint the exact intent of Israel in this current genocide that's unraveling was quite shocking, and to many people, of course, those who are not following news as close as we do, quite revealing of what this government of Benjamin Netanyahu intends to do in Gaza.
Mr. Levy, sir, very briefly for us, what is your understanding of this moment?
Nothing short of remarkable, actually, Dudu. I cannot speak as a South African, of course, but as a human, as a citizen of the world, this was an incredibly important moment, not only for international institutions that they perhaps still have a capacity to make a difference in a horrendous circumstance, but I would feel incredibly proud, and I would hope that South Africans from across your entire political spectrum would be able to look at this moment and feel pride, because I think this intervention in the short term may well save lives. I think Israel cannot simply glide over this, and I think at some stage we will look back on the history, hopefully, of a situation and a conflict that goes to a much better place. And we may well look at this as a watershed moment. I don't want to get carried away, but I would not think that is an overstatement. I think that is how significant today could be in historical terms.
Fair enough. Professor Magnus Killander, the Peace Palace was seized with hearing an application from South Africa that contains a request for provisional measures, and there's 9 provisional measures that South Africa is seeking. I would perhaps like for us to focus on Ms. Blind Nigralai's application, or rather dealing of the urgency and irreparable harm to indicate provisional measures. When we speak of urgency, was the condition of urgency met, and when is it met? Just hearing her very compelling argument today.
Yes, I mean, clearly it's urgent. I mean, it's already too late. I mean, for many thousands of people, and obviously the provisional measures come in at an early stage. I mean, this case was submitted on the 29th of December. Now we're on the 11th of January, which is very quick in international justice terms. The actual order by the court we can expect perhaps in in a few weeks, a month or so, perhaps even earlier. But that's what it has usually taken for them to issue an order of provisional measures. I can foresee that there could be some disagreements within the court on exactly, because I mean the court has in an earlier case, Ukraine versus Russia, held that it's not bound by the provisional measures as requested by the claimants, in South Africa in this case. So they could also develop their own set of provisional measures. So if they would go on the line that provisional measures should be issued, which clearly seems to be the outcome, I would say. If they wouldn't come with a decision on provisional, if they would decline to issue provisional measures, then really the reputation is on the line. In a similar line that what happened in 1966 following the Southwest Africa case against South Africa.
Mm-hmm. In fact, she went as far as saying the very reputation of international law to bind and protect all people hangs in the balance, citing that provisional measures were given in the Bosnia and Serbia case in 1993. She argues that that was not more compelling than this case, Gambia versus Myanmar, as you rightfully mentioned, Ukraine versus Russia. And so, Mr. Levy, sir, when we take a look and still sticking to the urgency and irreparable harm, just the details that we have heard, an acronym that some of our viewers and some of us were introduced to today, wounded child with no new family, citing pregnant women who are giving birth with no anesthetic, just the details that she has outlined. Would you argue that she managed to convince the court that there's irreparable harm here, because she also argued that Israel will not shoulder the responsibility of rebuilding Gaza once everything has been brought to the ground?
Well, it was a remarkable set of presentations by the person you're referring to, by the entire team. It's a lot to process. It's a lot to take in. I would urge people who are so inclined who didn't see this morning's proceedings to go back and watch this. I cannot, of course, speak to how the court will adjudicate. I think the case was powerfully made. I think, as has just been said, the entire court itself will be under a magnifying glass, and international legal justice will suffer a severe blow if some kind of provisional measures are not called for by the court. We will see that in what perhaps may be a short period of time. I think the team did rather well in preempting some of what we are likely to hear tomorrow from the Israeli team. And of course, whatever the court does will not be self-implementing. It will then depend on Israel whether it wants to be in violation of whatever is put forward. And crucially, it will depend on Israel's allies and backers who have facilitated and enabled this 3 months plus now of absolute horror and devastation to use whatever the court comes forward with as leverage to try and bring this to an end. And it's very important also that we heard the South African team acknowledge up front that the acts committed against Israel and Israelis on October 7th were themselves a crime. But I think what we saw today, and if I can just say, as someone of the Jewish faith, and as someone who also worked as an Israeli political appointee and negotiator in the past, I really hope this is a wake-up call. I was live messaging with many friends in Israel, and I'm not saying this is representative, but who felt that this was a tremendously tragic but also important and powerful moment, and feel that South Africa has done a tremendous service to the world in bringing this forward.
Mr. Fakude, sir, you outlined earlier the public relations nightmare that this may present or already presents for the state of Israel. And so South Africa's advocate Tembeka Toby concentrated on genocide intent, and he focused more so on the words of the leaders and the impact that it has had on the ground, which have been executed by the military, more so when he speaks of the biblical references on the invocation of Amalek to wipe out the seed of Amalek, and he showed videos of soldiers singing this. Some of the language that is used, describing people as human animals, saying erase them if you have an Arab neighbor, shoot them, quoting an Israeli official, using the words or focusing on the words that have been used throughout this conflict: exterminate, erase, etc. And so Advocate Mugaitobi argues that if what the Israeli leaders have said is not meant, or we should reject the notion rather that this was not intentional, or they did not mean this. And so when you speak of public relations, how should we have understood this argument when you focus on the language that is used to fuel conflict? Did he manage to convince the court, or convince you at least?
Yeah, well, we've been watching this and seeing it on the social media, and I think what happened today is the consolidation of all of these posts to an extent have been formalized. This is now a formal position that's presented to the world about how Israel regard the Palestinians. But I think what's important at this point is for the Israelis, particularly those that do not agree with the brute Benjamin Netanyahu, to come out and say, not in our name. And there are a lot of those in Israel who do not agree nor support the Israeli Defense Force in what they are currently doing in Gaza. So we need to have more and more of those on social media. We need to have more and more Israelis who are full-headed coming out and saying, not in our name. And as long as we have this silence and lack of participation or posting of counter narrative, you are likely, therefore, to have a nation that's going to be given this blanket description. And I think it's about time now, because we all know what the intention of Benjamin Netanyahu is, mainly trying to save his own skin, because he knows that after this, when the dust settles, chances are he might just be flogged to the Hague. So he'll do whatever it takes for him to prolong this brutality. He'll do whatever it takes for him to make sure that, he convinces even those that are not convinced that he was supposed to go to Gaza in the first place. That is the right thing to do.
Professor Killander, we also heard from Low KC on the provisional measures sought, and he said, well, those who are asking themselves, why did South Africa not bring a case against Hamas? He says Hamas is not a state and therefore cannot be party to genocide conventions. There are other processes to deal with that in a nutshell, rather saying that genocide is intent to destroy national, ethnic, racial groups, and no matter how appalling the provocation, genocide is never an appropriate response, and it can never be justified on any level. What is your understanding of this, or what do we need to understand about that?
Well, I mean, I see no reason to disagree with him on that. On that point, perhaps we can take up like what are these alternative measures that one can that one look at in that context, because obviously there are things that Hamas do and have done, and the situation in Gaza has been referred, or in Palestine in general, has been referred to the International Criminal Court, which is an alternative, a different court. The ICJ deals with state responsibility. The International Criminal Court deals with individual accountability, and I mean, there individuals on all sides can be held accountable for the violations that have taken place. Of course, it's Palestine that is a party to the ICC statute, so it doesn't. Israel is not, so it doesn't cover cover Israel, unless one would argue that the atrocities on 7 October would still fall somehow in the jurisdiction because of the planning and so forth that would have taken place in Gaza ahead of those attacks. So there are these individual accountability measures that exist in the International Criminal Court. One can also have, I mean, many states have extraterritorial jurisdiction in their national criminal law in relation to war crimes, crimes against humanity, genocide, and one could have have national trials as well. Obviously, those often have even more political implications than some of these state responsibility issues.
As we bring the conversation to a close, just one-word answer rather from our guests, if you would please indulge us. Professor Killander, we heard that the international community repeatedly failed. It failed Rwanda, Bosnia, the Democratic Republic of Congo, which is still today burning, was cited. The international community, we heard, continues to fail Palestinians. We heard that Gaza represents a moral failure that has repercussions not only for Gaza but for generations to come. Professor Killander, has the international community failed?
Well, I mean, I guess it has failed in so many conflicts around the world. But I mean, that's the problem is in relation to the enforcement of international law and international human rights law. I mean, we have all what people are supposed to do, but what is the action that one can take in relation to remedy? It's not an easy situation.
Mr. Levy, sir, has the international community failed?
Well, clearly, because that is what has led South Africa to undertake its own obligation under the Genocide Convention to put this case forward. And as the team noticed, the UN Security Council failed in its obligations. The chief prosecutor of the ICC has been dragging his feet under Western pressure. And so this is not just about saying, has the crime been committed? This is about trying to prevent worse things going forward. And I can tell you that in Israel, there is something of a more serious conversation that has been generated. And so already the act of this going to court has done something to shift the dial.
Mr. Fakude, sir, has the international community failed?
Well, it has failed, but I think what happened today gives a glimpse of hope, as I've said earlier on. And it hopefully is going to empower the ICJ to do its work that it's supposed to moving forward.
All right. Thank you very much to